Hello, this is Tahira Khan, and it's a great day at Aeon and Trisl. We have Mr. Amjad Ali Khan with us, who is the co-founder and former managing partner of Afridi Angell. Welcome to the office of Aeon and Trisl, Amjad.
Thank you very much.
And we are very lucky to have you here. Thank you for your time. I would like you to introduce yourself because I don't have the words for it.
I've been here 44 years with Afridi Angell.
Yeah.
I'm now retired from Afridi Angell, and as a lawyer. My practice consisted of acquisitions mostly, of hotels and restaurants in the real estate area. It's been a great ride. Dubai has been very good to us. We came here 44 years ago. Currently, I assist people in structuring businesses and assets, transferring those assets on to the next generation. And one of the issues that we have constantly is how these assets are booked originally, in whose name they're booked. So I'm not a real estate lawyer, but how you advise your clients to book their assets in what name affects me and my people I advise 30, 40 years later.
That's true.
If you look around the world, in every real estate transaction, lawyers are involved. In the UAE, they don't involve lawyers. What you need to do is to have maybe a lawyer in-house or a go-to lawyer who charges a nominal fees. The issue here also is that lawyers charge a lot of fees.
Yeah.
If you have a lawyer to whom you can go who charges the nominal fees, then he can guide your client, what the terms of the transaction should be. You look at the situation today, we are at war. And should there be a force majeure clause in the contract? What kind of force majeure clause should it be? So these are all very important issues, which I think only lawyers should decide. The lawyers need to meet your client.
Yes.
And if you're representing the buyer or the seller, and they need to be advised of the risks involved, and are they a cash buyer? Are they taking a mortgage? Are they buying off plan? All of these transactions have different risks involved. One of the reasons why they're having a problem is that they did not understand the risks properly. Nobody could have predicted the war, but nonetheless, you could have had a force majeure clause in the contract. And if they had force majeure, or if they had properly understood the risk, they'd be much better off today than be hyperventilating today.
I think also the other problem a lot of investors do is they become greedy and they invest maybe more than they can actually carry.
There is a real role for speculators. But what happens is that the ordinary man in the street believes that he can also be a speculator.
Yeah.
And that's where the problem comes in. You need to have professional speculators. I totally understand that. Professional speculators get hurt too.
Yeah, everybody does when, unpredictable things
situation,
happen.
right?
Yes.
But where you, as a realtor, come across a man on the street who's wanting to speculate, it's your job to tell him, this is not for you. This transaction is not for you. But where you have a speculator, professional speculator, then he has the money, he wants to speculate, that's his job. You need to fully understand your client before you offer him a property. Is he going to be a cash buyer? Is he borrowing from the bank? Now the banks have their own criteria in giving loans, but perhaps you could assist the customer also to say, should you be getting a loan or not? I had a niece who came to see me once from Birmingham, and she said she was going to buy a property. And I said, do you have the property? Do you have the money? She was a very young girl. And she said, no, I have money for 2 installments. And I said, go away.
Yeah.
You can't buy property. She said, no, I'll sell it before that.
Yeah.
And I said, no way. She didn't buy the property and the market crashed. She would have lost all her money.
And ended up in legal problems?
No, she didn't buy. She took my advice. If she did, she would have lost a lot of money. She would have lost all her savings.
So at what stage do you think lawyers should be involved in a transaction?
Right up front.
All the way, or
the thing is,
in the beginning?
If it is a small transaction, then you just want the lawyer to be involved in the sale and purchase itself. If it's a substantial transaction, then you can get the lawyer more involved. And the lawyer can speak to the client up front, see that the client understands the risks involved. There needs to be a requirement to get the lawyer involved, it should be the lawyer's escrow account that you're using.
Yeah.
The lawyer should be responsible to advise the buyer and the seller as to what happens if either party tries to walk away from the transaction before the closing.
Yeah. Or in case they are not able to.
If there is a force majeure event, then the lawyer comes in again. Money is with the lawyer. So instead of a realtor holding on to the escrow, it's the lawyer. Much better situation.
For both buyer and seller?
Buyer, seller, and for you. Let the lawyer make that call.
So, being a realtor, we all know it's a commission-based job. So, and here, as we discussed earlier, commissions are paid upfront. A lot of realtors, which doesn't happen everywhere in the world.
True.
So, do you think that has an adverse effect?
Absolutely. I think commission should be split. There should be a tail so that once the transaction is complete, then at that stage, the realtor should get all his commission.
There should also be some sort of responsibility.
Absolutely. So you're not just catching the man on the road, giving him a level of risk which he cannot handle or absorb or understand.
Yes, understand is a big problem. We see a lot of in our management, and they really discourage us to do, is to sell people who are not educated enough with the promise of selling halfway. So a lot of people get caught in that.
Yeah,
it's part of our training at Aeon and Trisl to not do that.
Absolutely, that's critical because people get caught in this, and it's a tragedy. Absolutely, well, they lose everything.
Yeah. What are the most common problems you come across during succession and transfer of assets?
Okay, that's an area which I do understand.
Okay, so let's talk about that. You used a term, it was like transgenerational something. So if you could explain that to us in English, that would be nice.
So when a buyer comes to you and says, I'm looking for such and such property and I want to buy it. So then you need to ask him, who will be registered as the owner of the property? Is it you yourself? Are you single? Are you married? Are you divorced? Are you a widower? So you need to understand who the buyer is. You need to really understand your client.
Yes.
And what he wants to do with the property down the road. Some people emotionally purchase the property with a minor child. That's a headache because you can't sell it then. Some people buy the property with their mother or father as their joint buyer, and they believe that once the parent passes away, the property will come to them. No, it doesn't. It goes to the heirs of the parent. Wow.
People actually don't think about this?
No, they think that they understand the problem. They don't.
Really?
You see, the UAE is a civil law country. It's not a common law country. Most of the people who buy out here come from common law countries. Pakistan, India, UK. And they believe that, perhaps joint ownership is joint ownership in the UAE also. Oh, well, it isn't. If you buy an apartment jointly with another, then in law, unless you signify other percentages of ownership, 1/2 belongs to one joint owner and 1/2 belongs to the other joint owner. If one of them dies, his half belongs to his heirs.
Even in case when the
ownership is joint. This is a civil law country. It's not a common law country. So that's something which is critical and needs to be understood. The problem arises, if there is joint ownership and they want to sell the property, well, you need consent of both joint owners.
Yeah.
And quite often,
they're not in agreement.
They're not in agreement. I've had many situations where a husband and wife bought the property jointly. The husband wanted to buy the property with the wife, and when he wants to sell it, the wife says no.
So what happens in that case? They can't sell it.
They can't sell it.
So let's say one of the spouse dies. Let's make it easy.
Yeah.
One of them dies. So then does the other one have the authority to sell the property?
No. Her share goes to her heirs. What happens in that scenario is if she's non-Muslim, Then they'll go look at her will. Is it a UAE will, Abu Dhabi will, Dubai will, DIFC will? There are all kinds of wills. But generally for non-Muslims, the will is straightforward. They execute, implement the will. Okay?
Okay.
And the husband has nothing to do with that. He can, of course, be the sole beneficiary of her will, which is simple. If the husband dies, again, if he is non-Muslim, they'll look at the will. And if the wife is the sole beneficiary, again, that's great. If they are Muslim, there are more challenges because, then they will look at Sharia. Who are the heirs to the husband? Are his parents alive? Does he have a son? These are all critical issues in determining who his heirs are. Now, recently, Abu Dhabi Emirate issued a law pursuant to which you can register a will in Abu Dhabi, which is not entirely in accordance with Sharia for Muslims. Okay. So that's a major new development. There's not much precedence as to how those wills are in practice, but when a person dies who's got an Abu Dhabi will, they can go to Abu Dhabi, get a succession certificate from Abu Dhabi, and then come and enforce it in Dubai, if the property is in Dubai.
And it cannot be challenged?
No. It can be challenged on normal grounds, Wills can be challenged, on the basis that there was influence or, the person was out of his senses and stuff like that. But
generally, no.
Generally, a federal law, which says that Abu Dhabi judgments will be enforced in the other emirates, not Abu Dhabi, but any Emirates judgments will be enforced in other Emirates and will not be challenged. So you get a judgment from Abu Dhabi, they go into execution court, and they're simply enforced. Simple.
So is that the case for all the other jurisdictions as well, as DIFC will and other wills? Or Abu Dhabi is the only one that cannot
So what happens with the DIFC will, which is for non-Muslims only, is that you get a DIFC judgment order, which then becomes, you get a judgment on the basis of that from Dubai courts, and that's then enforced throughout the UAE. So there's no issue there.
So how important is it for everyone to have a will?
I think it's very important for non-Muslims to have a will. For Muslims, you have multiple options. You have some of those options available for non-Muslims also. If they want their estate to be divided pursuant to Sharia, there's no issue. They don't need to do anything. If they want something else to be done, then they need to write a will. If the will is going to be in accordance with Sharia, no issues. They can write a will in Dubai, in the Dubai courts. If it is going to be contrary to Sharia, then they need to go to Abu Dhabi and register a will there.
And it will be implemented.
A better solution for non-Muslims and Muslims is to set up a foundation. So foundations can be set up in the DIFC or in ADGM in Abu Dhabi. And these are phenomenal structures. They cost a little bit of money, and that's why people stay away from them. Also, people who are not familiar with trusts don't like foundations either, because in this, you're transferring your asset during your lifetime to a company or to a foundation, to a structure. People feel a bit hesitant.
Yeah.
I worked all my life. I want to hold on to ownership.
You'd want to touch and feel it.
Yeah. In a foundation, you transfer the property to a foundation and you determine exactly what the distribution is going to be. Transfer all your assets and you say, this apartment goes to my son, this apartment goes to my daughter, this apartment goes to my mother. Total control over whatever you want to do. It's phenomenal.
Why don't people know about it? I'm a realtor. I've been a realtor for many years. This is the first time I'm actually hearing about this.
Foundations are new in Dubai, in the DIFC. I would say only about 4 or 5 years ago, the lands department announced that it was going to register foundations as owners of real estate. So you can have a company owned by a foundation which can buy real estate and they will be register it. So this is new. So that's why you might not have heard about it.
So the buyer is actually like a director?
The buyer can be a director. He can also be the founder. He'll probably be the founder of the foundation. And then he can have, the foundation has a council. The directors are actually members of the council. You need to have at least 2 members of the council. You and your spouse can be the members of the council, and you operate it. And there is this mechanism within the foundation to replace members of the council. It also allows you to have something called a protector to ensure that the members of the council follow the wishes of the founder in following the bylaws or whatever he wanted. However he wanted the distribution to be made, follow the rules of the foundation.
So, as realtors, what role can we play in making it easy for our clients' interest and their, protecting their investments?
The last issue which people think about is who's going to own this property?
Eventually.
Yeah. So they just say, okay, we've negotiated the price. I've got the bank line there. Okay, let's do the deal.
Yeah.
But you need to slow down the transaction a little bit and make the buyer think as to who's going to be the owner, who's going to be the owner in 10, 20, 30 years. Do I need a foundation? Do I not need a foundation? And initially, if he thinks that he wants his spouse and himself to be the owners jointly, and there is an emergency or there is a hurry in buying the property, he can buy it in his own name, pay the 4% transfer,
The DLD.
and then transfer that property to a foundation in which he and his wife are the beneficiaries, and it only costs 0.125% to transfer
Of the
that.
ownership, the value of the property.
Yeah, but he needs to have the property transferred into the correct ownership structure very quickly.
And this goes for like any size of property.
If it's an expensive property, then you must have a foundation, because you must think through as to where you want this to land up. Ownership of the
And
property.
does this also hold for short-term and long-term investments?
No, not for short-term investments, because foundations take some time to set up. And it's also expensive compared to just buying it in your own name. So if you're trading properties, then I would not recommend that.
So, like for example, if you are buying for long-term investments, then there should be
Correct.
a foundation.
Correct.
Which should actually have this whole structure. It's going to be an initial cost, but in the long run,
And a recurring cost.
and a recurring cost, which is less than 0.125, I suppose.
Well,
percent.
it depends upon the price of the property. So the recurring costs would be under $2,000
Annually.
annually.
Okay, so someone buying a large or expensive
Correct.
property should be able to afford
Absolutely. Absolutely.
that. Thank you very much, Amjad. It's been an absolute pleasure talking to you. Thank
Thank
you.
you.
Thank you. And I hope this is going to be an informative session, and anything in the future that we come across, Mr. Amjad Ali Khan is always here to help. If anyone wants to know anything, they can pass their questions to me and I will forward them to him. Thanks a lot.